the fact of the matter is the law that we have, particularly after 2010 Constitution, is extremely loud on you must let people be free even when they are charged, unless really it is demonstrated that they will there's flight risk, or and even in terms of what you if it's both bail and bond terms, they have to be reasonable. And I think Charlo, explained that very clearly, because people even require to be they need to be free to prepare for their defense. And if they are unreasonably held, then it means that their defense is being compromised. But I think one issue that we perhaps require to emphasize is these Gen Zs, these young people who are being arrested on terrorism or whatever other charges, and that idea of being moved from one station to the other and being tortured and coming to court, and maybe they are told that you can't say you were tortured. If you say that, when you come back, things will be hard on you. So the truth of the matter is, when the system realized that one way of defeating the demonstrations under Article 37 was to cause the terrorism and the goonism, and then decide that it is actually these young protesters who are coming with the flags and with some water and even some carrying a constitution and so on. When now they are the ones now who are told you are responsible for the destruction of property, you are responsible for burning police stations, burning courts, and so on and so forth. And yet it has been demonstrated clearly that, like the supermarket that was banned, it has been shown on video that was the handwork of actually police. We have seen again demonstrated, because of this era of social justice and those videos and TikToks and all that. We have seen the police and those people who are rendering this havoc, and we don't know whether this is just also police in uniform, in civilian clothes. We don't really know. Then we have seen them moving together. When they are doing some of those things, the police are there, and the police are not involved. I mean, they're just watching, and we have seen that. So actually, this is still a continuation of the state trying to make sure that the rights to demonstration, to protest, and all that cannot be enjoyed by the citizen. And I think this is the simple matter that we require to say, whether whatever forums we have, whether it's forums like in this Express, in Expresses, in the media, in interviews, within the courts themselves. We have witnessed more young people are being assassinated. Actually, the correct word to use is assassination. They are being assassinated, so that fear is really sown, and so forth and so on. One was able to follow a bit and even here we have been told about those cases in the Kawa court, so that the word goes around to all young people that now the state is not joking with you. The state is saying that you will you will now go for something serious, and then you have now some of these magistrates making sure, either out of their own volition or because they have been instructed by somebody within the state, to make sure that these kids are going to stay long in custody, in remand custody, and their parents and other parents are going to say, don't go to those demonstrations, because we are now reaching a point where we cannot afford the money to free you, if it's money, and even if it is other forms of bond, nobody will come out to now give those sureties for you. So I think it is important to really, and maybe before I make this appeal to the judiciary, because if you look at, I think Charlo was able to talk about the Prevention of Terrorism Act, which came into being 2012, and it has been, amended a bit. And according to, what Charlo told us, when you look at Section 2, which defines terrorist act, which is now used in the law later, now to say if you are, accused of terrorism, then this is how the law will treat you. It really very carefully tries to exclude things that are done in pursuance of a protest, demonstration, or stoppage of work. They shall not be deemed as a terrorist act within the meaning of this definition. And although there's a rider there that somebody would not be involved in use of violence against a person, has not endangered the life of a person, creates a serious risk to health or safety of the public or a section of the public, results in serious damage to property. Those four conditions, which could qualify the fact of, if you are demonstrating, you can't be charged with terrorism. We know for a fact that it is going to be very difficult to pin this to these young people, because the state knows that it's not them. The state knows that it's their agents who are doing this. And this is what really makes one, so very concerned, especially now Gen Zotes, very, very, very concerned, because what is happening, and I think this is something that Redemptor raised. When you mistreat young people like this, or you treat them in this fashion, and maybe after you have taken through all this, they come out. What kind of young people are we going to have? Because they are going to be very angry. They are already very angry with the country, because the country is not giving them opportunities. If they are looking for opportunities and then you do this to them, then this is double frustration. And so, you are creating a youth that is really going to know that the system, the government, the state is an enemy. And I think in other countries, people are careful, because it's like you're leading them to say, now we have very limited options, because we try to, ask for very ordinary things. We want a constitution. We want a country that works. And you are denying them, and instead you are saying, I'm going to ensure, you have no freedom, and you suffer until you decide that what you are doing is wrong, and keep quiet. So that is a concern. What is the effect of this upon our youth of the future? And these people will be the ones responsible at some point. So what are we doing to this young generation? And do we care? Do we care? Should we care for exactly what is happening? And now you have therefore the state with the citizen in the middle, particularly the young citizens, and you have the judiciary at the other end. And of course, when I say the state, there's also the DPP, that prosecution arm. You have the police the DCI, police, whatever, who decide that so and so needs to be arrested. They have done something wrong. Then then there's going to be prosecution, and when consistently you have arrests, then people are taken to court, and then it is said that let them be kept longer because investigations are going on. When you see that pattern, it clearly indicates to you that they are just being arrested so that they can be deterred, particularly if there is a nane. These terrorism charges are to possibly prevent a nane, and so on and so forth. So that it is now the state acting through the DPP, through the DCI, through whoever, so that the young people are told just, you give up whatever it is that you're doing, be good boys and girls, good quote, quote. We were told the church were inciting, we were told parents were inciting, we were told the opposition was inciting, etc., etc. And now when the citizen is in between, the young citizen, and the judiciary is now the recipient of these people who are brought up to. So the so in terms of the judiciary, now the judiciary has to ask itself, if these cases are being brought, then we are told in a consistent way that there is more investigation weight needed. And of course, even within case law, this is a matter where it has been indicated that the police or the prosecution must always bring people to court after adequate investigations, unless they can demonstrate that somebody is likely to flee and so on and so forth. So I think when one looks at maybe the magistrates who are doing these kinds of things, because these cases go to magistrates in the first instance, to me it appears as if those who are giving this impossible bail terms are actually sympathetic to what the state is doing. And I think it's also a minority, because the cases that have been taken to a minority of the magistrates that exist, not even within the higher ranks of the judges and so on. So I think it is there must be internal conversation within the judiciary itself, so that people who are doing these things within their channels of within the channels that they use. Of course, we know that everybody is independent to make decisions, but if things are happening consistently from certain magistrates courts, then I think the judiciary itself must have mechanisms to say that this is not correct, because on the whole, the judiciary has been, making judgments which help the citizenry when there's a lot of, state, the state wanting to put citizens down. We have seen some of that. Of course, we criticize and we say some, some parts of the judiciary might be, corrupt, but that should be looked at. So it is actually in the interest of the judiciary, which is one of the maybe the only arm of government that still makes us hope that a time is coming when the entire state is going to be reformed. So it is in the interest of the judiciary, in my view, to really have an internal dialogue, so that these courts that are trying to do something that will undermine the judiciary are themselves. And I think even what the Chief Justice did in terms of with the other actors within the legal sector. I think the conversation and the president of the Law Society was there and so on. And it was indicated even the magistrates must be, there was like a general direction that the magistrates must be sensitive, to these things. And one is actually looking at a situation where when these things are brought before them and there is no investigations, and it is said, we want to investigate more, we are investigating. At the minimum, they should give them a few days or not at all and say, bring these things when you have investigated. If you haven't, some of our decisions say that you can't do that. I think that for me, is something that is very, very important. And maybe we need to take, we need to seek from the Supreme Court an opinion. Can you really use the terrorism law to accuse people who have been in a demonstration? Can you use, the terrorism law? Because this law actually was used for, the acts that we know are real terrorism. So it is even undermining the efficacy of that law to be able to ask it to do what the penal code should do. And when there's real terrorism, even people will say, even those people are being unfairly accused because we have cheapened what terrorism is. And I think it will be important to look at also sections 32 and 33 of that terrorism act, because even there they limit how long the police can keep you, even if they're accusing you of terrorism, so that we look at the law in its holistically. And I think maybe that's why Maraga said today that this is just something being used to cower the young people, to keep them for a long time, and eventually it will be clear that you can't use this law as such. And let me end by saying this. Some people might find it controversial, but actually it is factual. When our former president, Uhuru Kenyatta, and William Samoei Ruto, when they were taken before the ICC, they were given bail. Actually, it was a bond. It was not even, they didn't pay money, if my memory serves me correct. And for things before the International Criminal Court, they were told, go home, but make sure that you come back for trials. And even sometimes, I think some of the trials were, I don't know whether they were virtual or even they didn't have to attend, their lawyers could proceed. So if for matters like that, and you are told you don't even have to pay a single cent, you just go home but come back. So why would we, and actually, I must say, even where I am, I'm tearing a bit. But so why would you really, these young people, you do this to them, some of them, even those who continue to be alive, you can destroy them forever. Why do we want to do that? And I think let me hebu nifike hapo, and I had some other small thing to do. If I don't stay a lot, then you will know that I am absent.